process for obtaining a domestic violence restraining order in family law courts is really twofold. So you have a temporary phase where you go in on very limited notice, between no notice and within 24 hours, and you request that the court issue a temporary restraining order. This restraining order has lots of boxes that can be checked off. So you can ask the person for 100 yards away, stay away orders. You can ask them to move out of a family residence. You can ask for full custody or have them have very limited custody of the children. And then you can also ask for financial orders, being that they maintain the status quo. They continue paying their mortgage. They continue paying the phone or the car bills. So you have to look at that process, and then you can go in. And remember, there is a much lower bar to go in there. The court really has a better safe than sorry stance on that, and will go in. However, there are lots of consequences to all of that. So now you have between 3 weeks and potentially months when the court will hear your permanent restraining order. The other side really gets to decide that. So if the other side wants to rush through and have their hearing on domestic violence, the court's going to hear it within 21 days. And if someone does that, it's likely going to be a very truncated hearing, and you really need to have your ducks in a row and your evidence ready to present it to the court as to why the court should issue a permanent restraining order. And when I say permanent, I mean 1 to 5 years with the ability to renew that restraining order. The court's going to be looking if the level of behavior has risen to a certain standard that's required under the Domestic Violence Prevention Act. And they're going to be looking at lots of factors to see what's happened. But again, the court could hinge on one factor and maybe a history of some other factors to grant that request. So many times there will be a text message that kind of exemplifies the violence that's occurring, or there is some kind of event that happens where the police are called, or there was an injury, or some event happened where, someone left the house in anger or told the person they had to leave or threatened the person. And that becomes kind of the key event of the evidence that you have to put on at your hearing. Discovery for your hearing is not a given anymore. So previously, a temporary restraining order was requested, and then it kind of opened the floodgates to discovery. The California courts have extremely limited that now. And in order to do discovery by the perpetrator or the alleged perpetrator of domestic violence, they have to get cause from the court. And the court's going to be very wary of giving that person the opportunity to do discovery, because it's not an opportunity or another opportunity to harass the victim or the alleged victim. So the perpetrator or the alleged perpetrator needs to make a call at the very beginning of this if it's going to be kicked out, so that they can make a request and do some discovery, or if they're going to try and rush and get to that hearing as fast as they can to try and get that restraining order knocked out and maybe to normalize the custody schedule as quickly as they can.